Appointment of a successor trustee simply refers to the process of having a new trustee take over. Most trusts are managed by their creators during the creator's lifetime, but trusts don't die with their makers, and that's why a successor trustee is needed to take over. Successor trustees step in to administer a trust, usually after the original trustee has passed or becomes incapacitated. Naming a successor trustee helps ensure uninterrupted asset management and wealth distribution without the need for probate court. In the next couple minutes, let's talk about how the role of the successor trustee and how successor trustees are appointed. What is a successor trustee? A successor trustee is a person or institution that administers a trust after a trustee dies or becomes incapacitated. Successor trustees are most often spouses, adult children, or trusted estate planning professionals or accountants. Sometimes there are multiple successor trustees who share responsibility for administering the trust. Most of the time, it's just one person or a single institution. A successor trustee may be designated as a sole trustee, but they're likely going to hire wealth managers, tax experts, attorneys, real estate agents, etc. to help administer the trust and its assets. How are successor trustees appointed? Successor trustees are appointed usually in the trust document itself. The trustor, the creator, will specify who they want to take over management of the trust if and when they can't do it, and when those that they name as successors can't do it. If no successor trustee is named, or the one designated refuses or can't serve for any reason, a successor trustee might be appointed by beneficiaries or a court. It depends on the state probate laws and what the trust says can or can't happen. Successor trustees have to willingly accept their role, usually by signing a consent to serve or an affidavit of appointment in some states. If an existing trustee wishes to change their successor trustee, they must make an actual amendment to the trust. Most courts won't accept informal, self-made changes. For these reasons, trust counsel should be consulted to make sure your changes are implemented and valid. How should I choose a successor trustee? Most people select a spouse, a child, or another family member as their successor trustee for their trust. But for larger trusts or more complex trusts, many trustors select an institution or a private trustee, like a private professional fiduciary, who's licensed and bonded and does this every day, as their successor. Sometimes trust makers designate a family member and an estate planning professional, accountant, or financial professional to serve as a co-trustee. Whatever the case, it's important to make sure that the person you choose as your successor trustee has the time, knowledge, and experience to administer the trust. It's also important to be honest and realistic about your family dynamics to avoid any miscarriage of what you really want to happen. A good trust attorney can help you take all these things into consideration and make the right choice. When can a successor trustee take control of a trust? Successor trustees take control immediately upon the death of the original trustor or the preceding trustee. If the original trustor is still alive but unable to handle their own affairs, say due to a medical issue, dementia, or Alzheimer's, for example, the successor trustee most likely will take over at that point. Most trusts contain provisions specifying how and when incapacity can be shown. Oftentimes a doctor or a designated third party will need to verify that the trustor is no longer able of managing the trust affairs. Family members who are beneficiaries or successor trustees usually are the ones to initiate a competency evaluation when that becomes necessary. And obviously, the original trustee can always voluntarily resign. Can beneficiaries stop the appointment of a successor trustee? Only if the trust gives them the power to do that, or they can prove that the successor trustee is unfit to serve in that role. And of course, courts have the power to remove or stop a successor trustee from acting if there are grounds for that. But usually the successor trustee is just whoever the trust says it's supposed to be. In some modern trusts, there is an unbiased and objective trust protector who might be identified with the authority to remove and replace successor trustees. Just depends on how the trust is set up. Who decides who the successor trustee is? Initially, the creator of the trust. They're the ones who pick the person or the institution. Where there is a shared spousal trust with co-trustees and one spouse dies, the surviving spouse usually becomes the sole trustee. A successor trustee usually only takes over after both spouses have passed or have become incapacitated. A co-trustee who becomes a sole trustee may or may not have the power to change successor trustees. For example, they might be able to identify a successor if they're going to step down. It depends on the terms of the trust. In multi-generational trusts or dynasty trusts, successor trustees often have the power to appoint the next successor. In cases where no successor trustee is named, or the designated successor can't or won't fulfill their duties for some reason, the beneficiaries may have the power to appoint a replacement. If they don't have that power, then the courts might need to be involved to appoint someone. Importantly, the trust will not be dissolved for lack of a trustee. You just have to go through the process to put someone in power. Does a successor trustee own the assets in a trust? Once the successor trustee accepts appointment as trustee, they transfer title to trust assets into their own name, but as trustee. They do not transfer it into their own name individually. Importantly, this does not mean that they own the assets personally. A trust is its own legal entity, and the trustee is simply the person managing it. Think of it as a company. It's the CEO. They manage the company. They don't actually own the assets. Successor trustees have to administer the trust according to its terms and for the benefit of the beneficiaries. They usually don't have the power to withhold distributions or disinherit beneficiaries, for example, unless the trust specifically gives them that power. Have questions about any of this? Give us a call, shoot us an email. Consultation's always free. Thanks for watching.